the history and authority of sheriffs from a sheriff. And especially for us, especially the team here, Ray has been our muscle. If any of you remember that video from the Missouri thing and the crazy professor is yelling, get somebody over here. Well, that's usually me yelling for Ray, saying, come here and get over here. So thank you, Ray. Appreciate you being part of this for so long, and really appreciate it. And of course, we'll do better next time and get him a little earlier in the program. But thank you so much.
Thank you, Peter. Thank you so much. And many thanks to all y'all for making our job easier. We start talking about security and stuff. You got to have cooperation, and y'all have been great. And we've had a wonderful security team, the deputies and police officers that have been here, as well as the Secret Service agents. Even TSA, I thought, did a pretty good job out there. I was really impressed with that. But thank y'all for making it enjoyable for us as well. And there's some bad things about coming on the agenda this late in the program, because you're following such a slew of great speakers. The good thing about coming so late in the we're patriots, right? You're the ones that stuck it out and stayed to the very end of this thing, because Thomas Paine warned us about those summer soldiers and the sunshine patriots. Although it is nice sunshine out there now, you're the dark cloud patriots. You're ready to stick it out through the storm, and I appreciate that. And what I want to share with y'all today is some of the history and authority of the office of sheriffs, because we hear this a lot of talk about this in the Patriot movement and the Liberty agenda is about what can our sheriffs do and what is all that about? How does that balance authority? And not only talk about the authority of the office of sheriff, but really talk about the authority of all of our elected executives at the state and local level. This is a very important thing for us to understand in terms of the balance of authority. So I'm going to go through some of these slides rather quickly at the beginning, and then get to really the heart of what I want to talk about today. So the office of sheriff really has the distinction of being the longest continuously existing non-military law enforcement entity in the history. Law enforcement, the public safety mission, has largely been conducted by the military, and that's true still today in many parts of the world. But the office of sheriff, the British common law that we brought over here when we first became colonies and later on gained our independence, brought with them a very colorful history. And we had some very colorful characters throughout history. I don't know what you think about when you think about a sheriff. Do you think about the Old West sheriff, in the old movies that rides into town and rounds up the cattle rustlers? Or do you think about some real life sheriffs? Some of these colorful guys that we had throughout American history, like Pat Garrett was one. Or maybe getting more into the modern era just a little bit, and think about Sheriff Buford Pusser from McNairy County, Tennessee, and the Walking Tall fame. Or some sheriffs you might be familiar with, Sheriff Joe, right? You've seen these guys around. Here's Sheriff David Clark from Milwaukee County, Wisconsin, and of course Sheriff Richard Mack, who founded the Constitutional Sheriffs and Peace Officers Association. And I love this picture of Sheriff Mack. I don't know if you can see it in the background, that sign that kid's holding. Has anyone seen my rights? And of course you can't talk about sheriffs without talking about America's favorite sheriff, Andy Taylor, and you can't talk about Andy Taylor without talking about who? His sidekick Barney, right? When I was in office, my chief of staff, and some of the folks from Dorchester County know him very well, is Barney Barnes. And so our running joke was every sheriff needs a Barney, and I had mine. Mine was a little bit smarter than this guy, I think. The history of the office, we can go back at least to the year 890 AD. So we're talking 1,100, 1,200 years ago. King Alfred was on the throne, and he wrote this document called the Book of Dooms. It sounds like some kind of modern-day video game or something, but really it was about crimes and punishments. In other words, if you commit this crime, if this is your offense, then this would be your doom, this would be your punishment that would go along with it. And in this Book of Dooms, he references a particular official, a particular official known as a reeve, R-E-E-V-E, kind of loosely translated as a guardian. And the reeve was the king's representative into a particular local area, a particular geographical jurisdiction. And the reeve was responsible for maintaining law and order and peace and safety within the community. They also did things like tax collection, mediated disputes. And they had the authority to call out something called the posse comitatus, which I'll talk about here in more detail in just a moment. And so these reeves were assigned to a geographical jurisdiction known as a shire. And we still have shires over there in England today, don't we? You got Devonshire, Lincolnshire, Worcestershire, if you need some steak sauce. And so the reeve was the king's representative assigned into a shire to do all of those things. So he was known as the Reeve of the Shire, or, got to get in line with my clicker here to hit the button. Okay, why is it not going now? There it goes. It's the Shire Reeve. And that's where we get the word sheriff from. So now you know that little bit of trivia. That could be the million-dollar question. You won't even have to call me for a lifeline. Now you'll know that where the term sheriff comes from. The term constable also has an interesting history. The constable was a quartermaster in the king's army, and he was known as a count of the stable. So now you know where that comes from. Fast forward a few hundred years, and we got the Norman Conquest. William of Normandy comes into England. King Harold is on the throne. King Harold is defeated, but William is so impressed by the tenacity, the courage, and the loyalty of the sheriffs that were there under King Harold's rule that he kept that office under his time of rule as well. And then we get, during this time, a list of duties. And it's interesting to me that the duties of the office of sheriff really haven't changed all that much in all these hundreds of years. Back during that era, the sheriff was responsible for representing the king. Now, I always like to say, well, we don't represent the king anymore. We represent somebody much more important than the king, because we represent you, the people, right, as your elected representative. And tax collection, believe it or not, there are sheriffs in certain states that still do this today. Louisiana is one of them, where the sheriff is responsible for collecting taxes. Now, I don't know how you do this, in all honesty. If you spend your time arresting people and collecting taxes, I don't know how you ever get reelected. You would think they would just have a bunch of single-term sheriffs, but they don't over there. Apprehending criminals on most wanted lists, assisting other sheriffs, operating jails. Most jails in America are operated by your local sheriff. Executions, they literally did that too. And not only the kind whereby you string somebody up from the tree or chop their head off with a guillotine or whatever else they may have done, we also execute orders of the court. We use that term today too. And as sheriffs, we are officers of the court. Again, we don't entertain royalty all that much. But the Magna Carta came out in 1215. Now, the Magna Carta was a really interesting document. For the first time ever in Western history, we have a constitutional document that is limiting the authority of the king. The nobles, and King John signed off on this thing, but he was under duress by the nobles. The nobles really interposed themselves, and we're going to come back to that term, between the king and the people. And he said, you know what? The king's authority is not sovereign. The king's authority is not limitless. There are limitations even on the authority of the king. And in the 63 clauses of the Magna Carta, we find that 27 of them specifically refer to the office of sheriff. He was that important of an official under the king's rulership. And the Magna Carta was a document. Our founders looked to this many hundreds of years later in terms of coming up with our founding documents and this whole idea of constitutional limited government. We can trace the history back. I think I'm standing and getting blocked by some of the equipment here. So nowadays in England, the office of sheriff is still there, but it's pretty much kind of fallen into disuse. There's a weakening of the authority. It's much more ceremonial in nature. But think about this. When the colonists came over here and began to colonize America, they brought with them the common law of England, and they brought with them this office of sheriff. And in 1634, we have Captain William Stone being appointed as the first sheriff on American soil in Northamptonshire, Virginia. And then look at this, just a few years later in 1652. Folks, this is 120-something years before we declared our independence from Britain. What are we doing in America? We're electing our sheriffs. We are electing our government representatives because we understood the power and authority that was attached to that. The power comes from the people. Our founding documents are very clear, and then you then entrust and share and delegate that authority with these officials that you have elected. And then something really, really important happened in 1735 in the history of the office of sheriff. Sheriff John Nash was elected. Happens to be one of my ancestors. I did the family research on this, and I think he's my 8th or 9th great-grandfather on the Nash side was a sheriff. We also have some on the Rabin side. My Uncle Joe Rabin is in the audience, and we have some law enforcement officials there too. And then we've got a little bit of statistics here. There's over 3,000 sheriffs in America. Almost all of them are elected. There are some appointed sheriffs, believe it or not, but most all of them are elected, and by virtue of that are accountable back to you, the people. Now, as we began our western expansion, we of course took the office of sheriff with us into the Wild West, and you had some really colorful characters that were sheriffs during that era. You may not have known this. People like Wild Bill Hickok and Bat Masterson, and we mentioned Pat Garrett earlier. I came across this quote from a book called The American Sheriff. It said, not only did the sheriffs do regular things that you think of as sheriffs, but they did some unconventional types of punishment, including execution by choking. Can you imagine being the sheriff? You're out there fulfilling the order of the judge and choking the guy out into choking him to death. So anyway, I thought that was interesting. Now, here's an interesting question. Now, those of you that I've had this discussion with are not allowed to answer this. The deputies in the back, you're not allowed to answer this. But the question is the agency properly called a sheriff's department, or is it properly called a sheriff's office? And why does it matter, and who really cares anyway? What do y'all think? I hear office is resounding out there, maybe the majority, and you're absolutely correct. Let me tell you why. This is a very important distinction. You'll see that sheriffs even disagree on this. We have sheriffs in South Carolina, for example. Some counties you have a sheriff's department, others you have a sheriff's office. So there's disagreement even among sheriffs. And as I get into this phase of my presentation, we're going to be getting into some areas that may be a bit controversial. And so stay tuned. I think this crowd can handle it. But this is an important distinction. So I went to Black's Law Dictionary to find out, because these are legal terms. And as Lauren said, it's very important for us to understand these terms as we are understanding these principles. So Black's Law Dictionary says that a department is a division of the executive branch of the government. It fulfills some type of administrative responsibility. So let's think about this for a minute. We're here in the city of Myrtle Beach, South Carolina. Myrtle Beach is a municipality under the laws of South Carolina. It's actually considered to be a political subdivision of the state. And because it is this government entity called the City of Myrtle Beach, within that government, we'll have departments. You'll have a police department. You'll have a fire department, a codes enforcement department, a planning department, a parks and recreation department. These are departments because they're divisions of this overall government that we call the City of Myrtle Beach. We see the same thing at the federal level, right? We have the Department of Energy, we have the Department of Defense, Department of the State, and so on. These are branches, or not branch is the incorrect word, it's a division of, in this case, the executive branch of the federal government. That's what a department is. It's like going to Walmart. All right, Walmart is a department store. So you have the men's department and the women's department and the sporting goods department and the houseware department and this department and that department, garden department, but it's all part of Walmart, right? These are divisions within inside. So an office is different in this respect. An office is a right and a correspondent duty to exercise a public trust. An office actually maintains a portion of the sovereign power of the state from a constitutional perspective. And this is very, very important for us to understand this. Because a sheriff fulfills an office, that office maintains part of that sovereign power that comes from you, the people. I mean, we don't call it a governor's department or the president's department or the attorney general's department. These are offices, and each one has been entrusted with a portion of that sovereign power. For those of you from South Carolina, you know that we call our chief prosecutors of a judicial circuit, we call them what in South Carolina? Solicitors. Other states, it's a district attorney or a state's attorney. Another carryover from our common law heritage, we call them solicitors. So back home in the First Circuit, we have a solicitor, David Pascoe, is a good friend, and he often would call me up and say, well, how are things at the sheriff's department? And I would say, I don't know, how are things at the solicitor's department? And he'd say, okay, you got me. Because it's a solicitor's office, right? And so I think it's important, the terminology that we use here, because there's power attached to these words. And this distinction right here is what gives sheriffs, as well as any other elected executive, the power and authority to stand on constitutional issues. You see, I've been a police chief before. I was police chief for 2 different agencies. And a police chief is an employee. A police chief works for the mayor and the city council, and if they tell the chief to do something, he's obligated to go do it. Now, if they tell him to do something illegal or unethical, he certainly can stand and say, well, I'm not going to do that, but they can also fire us behind, can't they? When I was police chief, we had this favorite saying that, sheriffs have to run for their job every 4 years, but chiefs have to run every day. And there was a lot of chiefs can be fired at will. So you really don't have the power to make these stands. And it makes me think about what's going on in Kentucky with Kim Davis, the elected county clerk that's there that made a stand. And we're going to talk about her in a minute and the stand that she made, and you'll see how it ties back into this idea. So when you're talking about an office versus a department, I want you to understand this concept of separation of powers. Now, when you were in grade school and you learned about American government, they told you that there were three branches of government, right? There's the executive, the judicial, and the legislative. And they are separate branches that serve as checks and balances on each other. You all remember that? And this is called constitutional separation of powers, and that's certainly true. That's one type of separation of powers that is contained in our founding document and very specifically laid out in the Constitution. We might call that a horizontal separation of powers within that level of government. But we also have a vertical separation of powers that the Constitution also speaks to. And that is that only certain powers are allowed or delegated to the federal government, right? There's only certain delegated powers. If you want a pretty much complete list of it, go to Article 1, Section 8, and you'll see a list in the Constitution of powers that we have delegated to the federal government. The 10th Amendment says that all those other powers are reserved to the states and to the people respectively. Unless it's prohibited by the Constitution, unless that power is specifically delegated to the federal government, it's maintained by the states. Well, now we have these elected officials, all of which hold an office that maintains a portion of that sovereign power of the state that was reserved to the states when we established and ratified our Constitution. All right, so that's the connection. Understand this vertical relationship. There's checks and balances there too. Our founders spoke to this. And one of the things that you get thrown out at us a lot of times is this idea of a supremacy clause. I was in a discussion with this with some friends of mine who happen to be assistant U.S. attorneys, and we were having a friendly discussion, and I mentioned Kim Davis, and I said she shouldn't have been put in jail, and the sheriff shouldn't have allowed her to be booked in and all this. And they said, well, no, she violated the federal judge's order. I said, yeah, but if she was to follow that federal judge's order, and it was one single judge issuing an order, then she would have violated the Kentucky State Constitution. And she would have violated the Kentucky state law. That's what she's sworn to uphold. And he said, yeah, but the Supremacy Clause says that all federal acts and all federal actions and all federal rulings take precedence because of the Supremacy Clause. I said, no, not so fast. Let's go back and read it, and let's see what it actually says. You can find it in Article 4. It says, the Constitution and the laws which shall be made what? In pursuance thereof. They only have supremacy over state laws and state actions when they themselves are consistent with the Constitution. You follow that? The founders put that little check and balance right into the wording of the Constitution. Now, this is not a new issue. This is something that was debated about during that particular time. Back during that day, we didn't have Republicans and Democrats. You didn't have, progressives and conservatives and stuff. That wasn't where the tension was in the political arena. In that era, the tension was between the Federalists and the Anti-Federalists, right? There were two groups. The Federalists said, you know what, we need to have a federal level of government. The Articles of Confederation are not sufficient to sustain us anymore, and they were making an argument for this federal level of government. And then you had the Anti-Federalists that were saying, not so fast. We kind of like the state governments the way they are, and we think the Articles of Confederation are fine. And if you do that, you're going to create this beast that's ultimately going to grow in power, and it's going to threaten our rights. And so there was a compromise that was reached, and part of that compromise was we're going to follow up the Constitution with a Bill of Rights a few years later, which is exactly what they did to further specify what those were. Well, Alexander Hamilton was a Federalist. He was one of the three authors of the Federalist Papers, along with John Jay and James Madison. James Madison being the primary author of the Constitution itself, and John Jay being our first Chief Justice of the Supreme Court that was established under that Constitution. They wrote a series of articles, and the article called the Federalist Papers collectively. And they were an argument as to why the Constitution, why the federal government was a good idea. And in Federalist number 78, look what Hamilton, the Federalist, said. He said, no legislative act, therefore, contrary to the Constitution, can be what? Valid. It is impossible for it to be valid if it's contrary to the Constitution. If you were to deny this, then what you're really saying is that the deputy is greater than his principal. Well, what does that mean? Well, for example, we've got deputy sheriffs here, right? They work under the sheriff's office, and they were sworn into office by their sheriff, Philip Thompson. Good man, good friend. Who has more power, the sheriff or the deputy sheriff? The sheriff, that's where their power comes from, right? So if you're going to argue that the federal government can claim powers that were not delegated to it, then you're saying that the deputy is greater than the principal, that the federal government is greater than the state governments which created it. Very important distinction. Goes on to say the servant being above his master, the representatives of the people are superior to the people themselves. This was a nonsensical argument to Hamilton. And he went on to say that men acting by virtue of powers may do not only what their powers do not authorize, but what they absolutely forbid. Does that sound familiar? Does anybody see a parallel with what's actually happening today? Because we've fallen into a trap of believing something that's not true. The United States Supreme Court does not always get it right. Every now and then they'll get it right. They used to get it right more often than they get it right now, all right? And in one of the early cases that every lawyer is familiar with, Marbury versus Madison, an 1803 case, the United States Supreme Court said this: Constitution are what? Null and void. They are of no effect. They don't accomplish anything. Now, there were other things in Marbury that I might have argued with them about, but this I agree with them on. TJ comes to our assistance, right? Now, Thomas Jefferson was an anti-federalist. He, along with others like George Mason and others, were saying, no, we need to stay with the states. And Jefferson said this: to consider that the judges are the ultimate arbiters, the final say on constitutional issues, is very dangerous and can lead us to a what? A despotism of the oligarchy. Can't you love the way TJ can spin a phrase? I mean, a despotism of the oligarchy. And what he's saying is, you can't leave it up to the Supreme Court. You can't leave it up to the federal judges. They do not have the final say. If you give them the final say, that's another form of tyranny. That's another form of despotism. Because now we've got these unelected judges that are making these decisions. How many of them? 5. Thank you. Because all you need is a majority. All you need are 5 unelected lawyers, no offense, Lauren, to make these decisions, if you believe what a lot of people are believing today. Thomas Jefferson said the BS meter went off with him. He said, no way. And so there's another famous case in the 1880s, out of North Carolina. An unconstitutional act is not law. It confers no rights, it imposes no duties, it affords no protections, it creates no office. It is in legal contemplation as inoperative as though it had what? Never been passed. It's null and void and of no effect. This is our Supreme Court recognizing this fact. So let's go on with some other little quotes here, because this isn't what Ray Nash is saying. I don't want you to leave here and say, oh, Ray Nash got up here and said this. This is what the founders are saying. You know, they wrote this stuff down. You know, nowadays we got YouTube, we got video, we record everything, Facebook. Just wrote it down, and you know, the authors could go back and see if they got it right. And there's volumes and volumes of this. There's libraries full of this. You can go down and check it out in the library now. You can look it up on the internet. Check your sources, but you can look it up on the internet. Go back and see what these founders said for yourself. Don't take other people's word for it. Don't take my word for it. Go do your research. That's what else TJ had to tell us. Whenever the general government, and that was their term for the federal government, the general government, whenever it assumes undelegated powers, powers that are not spelled out in the Constitution itself, its acts are what? Unauthoritative. They are void. They are of no force, as the Supreme Court said, as inoperable as if they had never been passed. This government, talking about the general government, created by this compact, talking about the Constitution, was not made the exclusive or final judge of the extent of its powers, because that would have made its own discretion, its own opinion, superior to the Constitution itself. There's absolutely no way. So the federal, don't look to the Supreme Court. The Supreme Court is part of the federal government. Why would you create a government, which the states did through the Constitution, this compact? States came together into an agreement and said, these are the powers that we're going to delegate. How would you let the creature of that compact decide for itself what powers it has or doesn't have? Yet we've been tricked into believing that, haven't we? As a culture. Y'all not so much. He went on to say in the Kentucky Resolution, the principle and construction that gives the general government to be the exclusive judge of the extent of his powers stops nothing short of, and he uses that term again, despotism. It's another form of tyranny. James Madison, the primary author, another Federalist, the primary author of the Constitution, said, in case of a deliberate, palpable, dangerous exercise of other powers not granted by the said compact, the Constitution, the states, who are the parties thereto, have the right, and in fact, they are what? Duty bound. They don't just have the right, they don't just have the option. According to Madison, they have the duty to do what? To interpose. You hear this term interposition? This isn't a new term. The founders were talking about this stuff. The states are duty bound to interpose for arresting the progress of, what did he call it? What did he call it when the federal government steps out of its constitutional framework? Evil. That's exactly what he called it. He understood what would happen. Got a couple more for you. He went on to say, where powers are assumed which have not been delegated, a nullification of the act is the rightful remedy. He told us right there in the Constitution. It is the right, in the Virginia Resolution, that is the rightful remedy, nullification. That every state has a natural right, in cases not within the compact, to nullify. We heard about the nullify Obamacare thing, right? This is where the terminology is coming from. To nullify of their own authority. They don't have to ask for permission. They don't have to ask for permission from the federal government. They don't ask for permission from the Supreme Court. They don't ask for permission of the other states. Every state, acting of their own authority, can nullify any assumptions of powers by other governments within their jurisdictional limits. That's why the stuff about having state and local officials that understand their constitutional authority. When can we stand? When can we make that interposition? And when should we? Only when it's an unconstitutional act, by the way. That's a very important distinction to understand. It's not just because you don't like something the federal government did. It has to be an unconstitutional act. Hamilton went on to say in Federalist 33, if the federal government should ever overpass its just bounds and make a tyrannical use of the power, the people whose creature it is, the people have created this monstrosity of a federal government, they must appeal to the standard they have formed and take such measures to redress the injury done to the Constitution as exigency may suggest and prudence justify. You know what Hamilton was saying? All options are on the table. And that's what he was saying. Depending on the exigency, depending on understanding the need for prudence, understanding the need for discretion and good judgment, all options were on the table as far as he was concerned if the federal government exceeded its boundaries. And of course, my favorite founder, Michael Peroutka. Don't know about him, right? He actually wasn't the founder. Some of y'all in the room might recognize him. Michael Peroutka is a constitutional attorney in Maryland, and he really is a mover and a shaker in the liberty movement. He founded the Institute on the Constitution, which is a training program that you can go through to learn more about being a constitutionalist. And I was at the Constitutional Sheriffs and Peace Officers Conference a few years ago, and he said this from the podium, and I wrote it down. He says, when a police officer or peace officer refuses to enforce an unconstitutional act, he's not breaking the law, but what? Upholding the law. Now, an interesting thing happened at that conference in that Michael Peroutka went to his hotel room and he set up a video camera. And he brought the sheriffs in one by one, sat them in front of the camera, and he interviewed them. And he asked them the following question. He said, Sheriff, if the federal government, agents of the federal government should come into your county, and let's say they were going to seize firearms in violation of the Second Amendment, would you and your deputies participate in such an unconstitutional act? And of course, every sheriff said no. I mean, we were at the Constitutional Sheriffs Conference, for crying out loud. You know, hopefully that's the kind of sheriffs that were there. And one after another, they said, no way, we believe in the Constitution. We believe in the Second Amendment. My deputies and me, we are not going to participate should the federal government come into our county. They cannot count on us for additional manpower and so on. And so it got to be my turn to be interviewed. And I was honored to do it because I'm in retired status. So I'm honored to even be included. And he's got me in front of the camera and he asked me that question. And I said, well, of course not. I said, but you're asking the wrong question. He said, what do you mean? I said, you should be asking us, what are we going to do to prevent it? So that's a whole different question. And that's a harder question for sheriffs to really understand and to agree with to a large, now it's growing. This constitutional sheriffs movement is growing, and I'm really encouraged by what I'm seeing happen with people like David Clark and others that are kind of taking the stage and educating not just the people, but the sheriffs themselves, about their constitutional authority and that right balance of power, that separation of powers that we talked about vertically between the federal government and the state government. I always like to say it more like this: state government, federal government, right? Because we know which one should be supreme in those types of situations. Because if what the Supreme Court said is really true, and if what the founders said is really true, and if you believe Madison, Hamilton, and Jefferson and others, and that if any unconstitutional act is null and void, if an unconstitutional act is as inoperable as if it had never been passed, if it has no effect, and if the proper remedy is to nullify and interpose between the federal government and the people, then we got a whole nother ballgame talking about here. Because what that means is that the federal government comes in and attempts to seize firearms, let's say, in violation of the Second Amendment, we have a word for that. It's called a theft. All right? If they come in and kick in a door to serve an unconstitutionally issued search warrant issued by a federal judge, we have a word for that too. It's called a burglary. And if they attempt to arrest someone pursuant to some unconstitutional executive order, let's say, we have a word for that too. It's called a kidnapping. These are criminal offenses. And the sheriffs, you elect us to protect you from criminals. And I don't care if the criminal is a thug on the street or it's a thug in the federal government. If they're operating outside of constitutional authority, there's no foundation. That's what Lauren was talking about. Where does the authority come from? It comes from you, ultimately. You've delegated a portion of it through your states to the federal government. The rest you've retained for yourselves according to the 10th Amendment. There's a separation of powers vertically, and the proper and rightful remedy, according to the very men that wrote the document, is to nullify and interpose. So I kind of think of it as a continuum, maybe. Maybe there's a way to think about it, and then I'll stop. At the very low end of this continuum, we have the ballot box. We're supposed to go and elect our representatives. We try to elect people that understand these principles and will stand for them. You've heard a lot of them up here talking about this entire conference. And then maybe the next step, you got like a redress of grievances. If you think about the Declaration of Independence, it was a redress. It was a list of grievances against the king, right? It's like if you printed the Declaration out on 12-point font Times New Roman, script on your Microsoft Word computer and printed it out on 8.5 by 11 paper, it'd be about 4 pages long. The first page would be all the stuff that you know about. When in the course of human events it becomes necessary for one people to dissolve the political bonds with another, and you get all that stuff. The last 3 are going to be grievances against the king. I would encourage you to get that document and read it. Something we've got to read probably once a year, just kind of keep it fresh. And just substitute the word king for federal government and just see how close we are to where the founders felt like they were in 1776. So you got a redress of grievances, let's say, and then you got nullification. You got where the states say, well, all this other stuff didn't work, so we're just gonna act like it didn't even happen. It's of null and void and no effect. It's inoperable. And if they continue to push it, then you got the interposition. That's where you have the state and local officials that have to make a stand to say, no, you've crossed the line here. We've been elected to hold on and maintain and preserve, protect, and defend a portion of that constitutional sovereign authority of the state, and that's what Kim Davis was doing. Now, I disagree with Kim Davis, not on what she did, but on why she did it. She made an argument on religious liberties. I don't think that's the right argument for her. I think she was the right action, the wrong argument. The argument should have been separation of powers. The Supreme Court has acted unconstitutionally. They have rendered a ruling, an opinion, that is unconstitutional. You have a federal judge that is now acting upon that and ordering a properly elected state official to do something not contrary to her religious beliefs, which it was, but contrary to the very constitution of the state that she represents. That's the argument I think that she should have made, because that's the one that's going to get us out of this. And we've heard Article 5 Convention of the States. It's in there, in that thing, in that continuum. These are all tools. Maybe, I hate to say this, but maybe secession, but that's way out here. So let's just take that. Let's just take that, set that aside, and look at all these other tools that we have, and let's start exercising those, because these are the tools that our founders gave us to get things back on track when the train jumps off the track. Thank y'all so much for allowing me to come and present and spend some time with you. I love y'all. Y'all are the hope for America's future. Encourage your sheriffs. Encourage your law enforcement officers. They need it. They need to hear from you. Thank you.